Hello, I am Naavi of www.naavi.org. Today, I would like to discuss some aspects of Section 65B of Indian Evidence Act, which has caught the attention of the legal fraternity of late, because Supreme Court in one of its judgments pointed out that electronic evidence needs to be produced with a certificate as provided for under Section 65B. This particular section has been in existence since 17th October 2000, when Information Technology Act was notified. And in fact, one of the first cases in which I produced this particular evidence was in the case of State of Tamil Nadu versus Suhaskatti way back in 2004, in which a document which was present in Yahoo e-group was brought to the court as admissible evidence with my certification, ultimately ending up with the conviction of the accused. Subsequently, on several occasions from Cyber Evidence Archival Center, I have produced evidence which has been taken for consideration in the courts. Those who want more details of this can refer to www.ceac.in. Today, I would like to discuss some misconceptions which are floating around in understanding the Section 65B and place my views for further debate. The key elements which I would like to address are: one, the concept of primary and secondary documents when we are discussing electronic documents. Second is the format in which Section 65B certificate has to be produced and who can certify. Now, this Section 65 capital A section was introduced in Indian Evidence Act immediately after Section 65, which addressed the production of secondary documents as evidence. Therefore, there is always a confusion whether Section 65 capital A refers to the production of secondary evidence in respect of electronic documents. But if you look at this particular section, it says that this is a special provision as to the evidence relating to electronic record. It doesn't say it is a special provision related to the secondary documents in electronic form. And it simply says the contents of an electronic record may be proved in accordance with Section 65B, which provides the greater details as far as the procedure is concerned. There is no mention in Section 65A as to whether this applies only to secondary documents and not to the primary documents. In fact, this distinction between primary and secondary documents is, in my opinion, misplaced as far as electronic documents are concerned, because we know that any electronic document, whether one would like to call it as primary or secondary, is actually humanly not readable. It is a binary document which can be interpreted by a binary reading device like a computer running with a particular operating system and an application. The interpretation makes the binary document understandable by a human being. So therefore, every electronic document produced for the consideration of the court has to be interpreted by a human being, and that person, you may call him as the expert who certifies what the content of the document is. Sometimes people say that the hard disk where a original document which is brought into evidence is there as the primary evidence. But this again is not, in my opinion, an appropriate interpretation, because a hard disk is only a container which contains the electronic document, but it is not the electronic document itself. Even in the case of a CD, where only one single let us say electronic document is present, I would like to call it as a container, and the electronic document itself is an expression in binary form, zeros and ones, and that is something which cannot be humanly uh, read. Therefore, even when a judge reads an electronic document by fixing a computer in his courtroom, what he is doing is he takes on the role of interpreting the electronic document, and while he is welcome to do that, in most of the other cases a judge would prefer a third party whom he can call as the expert to actually interpret and provide a direction to the provide information to the court that this is what the electronic document is said to contain. Now this interpretation is very important because the human understanding of an electronic document is dependent on the electronic document being converted with the use of the devices in hardware and software. If there is any error in this hardware or software, it is possible that the interpretation would be incorrect. That's why there is a need for certification of any electronic document as envisaged under Section 65B. Now Section 65B actually talks of the manner in which a certificate has to be produced, and it refers to something called the computer output and says a computer output of an electronic document is admissible as electronic evidence provided it is either printed on a paper or copied on a media, and it sets out certain conditions. So if you look at this section closely, there are two ways or versions in which an electronic document can be produced as evidence in a court of law. One is as a printout, another is as a copy. Now in either way, the document is produced out of an electronic document which is otherwise present on a computer and is being seen. In fact, it is the process of converting the electronic document as seen on the computer into a printout or a copy is what is referred to under Section 65B as an activity for which certain certification is required. Now in fact, the section makes reference to certain keywords called said activity, a computer, said period, a person with lawful control, etc. Now all these terms need to be properly identified to appreciate Section 65B. Now when we say it is a said activity, the said activity is actually production of the computer output, which means taking a printout or taking a copy. So that is the said activity which Section 65B recognizes, and it recognizes that a computer is used in taking the computer output, and that computer is one on which the document is seen, and the printer which is a peripheral associated with this, and the two together is a single computer. Then there is this mention of said period. Now this said period is also sometimes misunderstood. The said period in respect of Section 65B refers to the taking of the computer output, which means the period in which the printout is being taken to convert the electronic document into the paper form. It may take 1 minute, it may take 2 minutes. If there are 1000 pages, it may take half an hour. That is the period which is being referred to as Section 65B. I can give an example here. Let us say that there is a bank statement which is there in a computer, and it refers to the period, let us say 2014 to 2015, a particular period. Now, the statement refers to transactions during a period, but the printout is being taken today in a single minute or a particular time when you give a control P command and it comes out. Now when we talk of the said period, we are talking of this 1 minute period when the printout is coming out, and not the 1 year period for which the transactions in the document refer to. Therefore, when we say the computer must be working properly, we are not talking of a computer working properly for 1 full year, but it is for the period in which the printout is being taken. Similarly, when we talk of the person who has got a lawful control of the computer is recognized, that is the person who actually takes the computer output for the purpose of section 65B, which is the printing of the document. It is not the manager of the bank who is the owner of that content called the statement of account. Now this important distinction of the computer output under section 65B being different from the content which is there inside the computer is important for us to recognize. Without this, we will be only misinterpreting section 65B. Now, having said this, that is, one, we are taking a computer output, and that computer output will be either in the print form or in a copy form, and in either case, we are not discussing whether it is primary or secondary. It is a document which is admissible under section 65B. Now we will see what should be the element of the section 65B certificate. One, the section 65B says that the certificate should identify the electronic document which is being taken in the form of a computer output. It should describe the manner in which the computer output was produced, what were the devices used for that purpose, and it should contain the signature. If it is a printout, then a physical signature. If it is a copy, perhaps the digital signature. And the person who has to give that certificate should sign, and that person who signs should be a person occupying a responsible official position as to the device which was used for the purpose of taking the output, which means the owner of the computer in which the electronic document was seen and then printed out. Section 65B also tries to provide some clarifications. One of the things it talks about is combination of computers, using of computers over successive periods of time, in combinations, in successive operations, etc. Now these are all technical aspects which refer to, for example, when there is a distributed database, data elements lie over multiple computers, and when you are viewing an electronic document, the electronic document is dynamically created by pulling the information from various servers. Similarly, while the information is pulled from various places, it hops over many other computers. For example, in the case of an internet, a Yahoo document, before it comes and lands in your computer, passes through maybe 15-20 other computers. Now, each of these is a computer system. Each of these has got a lawful owner of the computer, and the particular electronic document passes through all these documents. But what is important for the purpose of section 65B is the final computer in which the certifier is viewing the document and then taking the printout. Now, within this, there are softwares working, and sometimes the software will be acting in steps. It does something first, and then that output is taken to the second operation, third operation, and so on. This is what is referred to here as using of a computer in succession. This does not mean that a computer today is being replaced by another computer tomorrow, or the software today is being replaced by another software tomorrow. This combination, succession, successive use of computers, etc. refer to the way software functions and the way information is collated on a dynamic basis for the purpose of constituting the electronic document which is an evidence. Now, when we talk of who is certifying the Section 65B statement, there is a need for us to distinguish between whom we normally call as an expert. An expert is one who actually interprets the content. Here we are not talking of that expert. Section 65B envisages conversion of an electronic document into a printout. Now that also requires some expertise, but that expertise is only in how to operate a computer, how to view the relevant electronic document, and how to take a printout. So that person is the person who gives the Section 65B certificate, not the person who can interpret the content. If, for example, there is a bank statement in which there is a debit entry to CLG, rupees so and so. Now, the person who is giving Section 65B certificate need not know what the abbreviation 65B or CLG means. In fact, it is the official of that particular bank who can perhaps come on witness and say CLG means so and so. So, interpreting the content is different. Taking a printout is different. The two are done by different people, can be done by different people. Maybe in certain cases both can be done by the same person, in which case the expert himself gives the evidence as to the content and also produces certain documents to substantiate his own statements made orally on the witness box, in which it needs to be certified by him under Section 65B. But in most of the normal cases, the job of a Section 65B certifier is like a photographer who takes a photograph and says, this is what I captured on such and such a day when I use such and such a camera in such and such a way. He does not go on to interpret what his photograph really means. And now this distinction is very, very important, because this has got implications on how we interpret the person who has to sign the certificate. If we don't adopt this particular approach, in the case of an electronic document which comes over the internet, there will be 10, 20 people who will all be lawful owners of the computers, who are all genuinely responsible for the processing of the particular electronic document, but all of them cannot give a Section 65B certificate. So what Section 65B certificate means is the end product, which is the electronic document, which is viewed and reproduced for the purpose of the court's use. Now all these aspects are yet to be fully understood. Even the courts, I feel, need to perhaps see that there is no confusion as to how we interpret Section 65B. But what I would like to place on debate is, let us not interpret Section 65B as a certificate of an expert who is interpreting the content. It is only a certificate issued by a person who converts an electronic document which he can view to a paper document, so that the court can take that further for its own purpose of considering it as an evidence. Now this clarity needs to be brought into the community, otherwise there will be one demand from all internet service providers and system admins of the ISPs and the mobile service providers to provide Section 65B certificates for everything. They are not required. Suppose if I as an administrator of a company can view my log records on a cloud computer, I can provide Section 65B certificate. I don't have to ask the Amazon cloud administrator to give a certificate. So Section 65B, if it is properly interpreted and used, can provide evidence even if the evidence is lying on a cloud computer or in a remote computer across the world. There is no need to insist that in order to bring electronic evidence to the courts of India, the servers have to be within India or something like that. if a person in India has got an access to an electronic document wherever it is situated and it can be viewed from India, that evidence can be captured and produced to a court of law with section 65B certification, and that is the real purpose of section 65B. Now this is my view. If there are any counter views, I would be quite happy to receive the views and we can debate. Thank you.